I never told my mom what was hidden in Dad's warehouse. Not because I wanted to keep secrets, but because some truths are safer locked away until the right person asks the wrong question. My father died when I was 19, leaving behind a commercial property management company, 3 storage facilities, and a single-bay warehouse in an industrial park 20 minutes outside Louisville. Mom inherited everything. She also inherited the grief, the paperwork, and the slow unraveling that comes when you lose the person who handled all the details you never wanted to learn. For 6 years, I helped her manage the properties. I learned the lease agreements, the maintenance schedules, the vendor contracts. I became the person Dad had been, quietly competent, rarely emotional, always 3 steps ahead of the next problem. Mom appreciated it, but she never loved the work. She loved Dad. The business was just a reminder of what she'd lost. And she met Gordon at a charity auction in the spring of 2019. He was 52, recently divorced, friendly in a performative way that made my shoulders tense whenever he shook my hand too long. He worked in pharmaceutical sales, drove a leased Audi, and talked about disruption and optimization like they were virtues. Mom was lonely. I understood that. But I watched the way Gordon's eyes moved across the financial statements she sometimes left on the kitchen counter. The way he asked questions that sounded casual but mapped our assets with surgical precision. They married in November, 8 months after they met. Small ceremony, immediate family, no fuss. I stood beside her and smiled because that's what you do when your surviving parent finds something that looks like happiness. Gordon moved into the house where I'd grown up, the house Dad had paid off in 2011. He brought his furniture, his opinions, and a confidence that filled rooms before he entered them. The first 3 months were fine, surface fine. He deferred to Mom on business decisions, played the supportive husband, even complimented my work ethic in front of her friends. But I started noticing small things. Documents refiled in drawers I'd organized. Vendor contracts reopened for renegotiation without my input. A property management software subscription I'd never authorized, billed to the company account. In February, Gordon suggested we sell the warehouse. He brought it up over Sunday dinner, casual, reasonable. The building had been vacant for 4 years, he said. The property taxes were $12,000 annually. The roof needed work. We could liquidate, reinvest, simplify the portfolio. Mom looked at me. I set down my fork and said the warehouse wasn't for sale. Gordon smiled and asked why. I said it was complicated. He said he'd love to understand the complication. I said maybe another time. His smile stayed fixed, but his eyes shifted into something colder. At night, I drove to the warehouse. I hadn't been inside in 11 months. The building sat at the end of a gravel access road, behind a machine shop and a tile distributor. 16,000 square feet, concrete slab floor, steel frame, loading dock on the north side. I unlocked the pedestrian door and stepped into the smell of old cardboard and motor oil. The main floor looked empty, just a few pallets and a rusted shelving unit Dad never got around to removing. But I walked to the back corner, to the utility room behind the electrical panel, and opened the secondary door with the key I'd carried on my ring since the day of his funeral. Inside were 42 file boxes, labeled in Dad's handwriting, stacked floor to ceiling. Contracts, receipts, correspondence, financial records spanning 30 years. Not the kind of records you keep in a filing cabinet at home. The kind you keep because someday someone might need proof. Proof that a loan was repaid. Proof that a settlement was honored. Proof that a partnership dissolved cleanly. Dad had been methodical about documentation, obsessive even, and when he got sick, he told me exactly where everything was and exactly what it meant. He also told me never to tell Mom. Not because the records were dangerous, but because she'd want to throw them away, to purge the past and move on, and some of those records protected us in ways that wouldn't be obvious until someone challenged the wrong thing. So I'd kept the room locked, the boxes untouched, the secret small and silent. I didn't know Gordon would become the wrong person asking the wrong question. But 3 weeks after that dinner conversation, I found out he'd contacted a commercial real estate broker and requested a valuation on the warehouse without telling either of us. The broker, a guy named Tim Carlisle who'd worked with Dad for years, called me directly. He said Gordon had identified himself as a principal in the business and asked for an expedited assessment. Tim wanted to verify the authorization before he proceeded. I told him to hold. I'd get back to him. I didn't confront Gordon immediately. I watched. I reviewed the business bank accounts and found 2 transactions I hadn't approved. One was a payment to a consulting firm I'd never heard of. The other was a retainer to a law office in Lexington. Both were under $5,000, small enough to slip past casual oversight, large enough to fund preliminary work. I pulled the corporate filings and saw that Gordon had requested access to the Kentucky Secretary of State business portal using Mom's credentials. The request had been approved because he was listed as her spouse, and she'd signed a notarized consent form I'd never seen. I made copies of everything. I documented the dates, the amounts, the entities involved. Then I scheduled a meeting with our family attorney, a man named Paul Everett who'd handled Dad's estate and knew every clause of the operating agreements that governed our properties. I brought the documents in a manila folder and laid them on his desk without preamble. Paul read through them slowly, his mouth tightening. When he finished, he looked up and said Gordon was attempting to establish operational authority without formal partnership status. If left unchallenged, it could create a legal presumption of joint control, especially given Mom's marital relationship and her recent inattention to procedural details. I asked what that meant in practical terms. Paul said it meant Gordon could potentially force a sale, restructure the business, or dilute my management authority by arguing that marital property laws gave him an ownership interest. Kentucky was not a community property state, but equitable distribution applied in divorce, and a smart attorney could leverage that ambiguity during marriage to justify operational involvement. The consulting contract and the legal retainer suggested Gordon was building exactly that case. I asked Paul what I needed to do. He said I needed to document my sole management authority, reassert operational control, and get Mom to formalize the separation between marital assets and business assets through a postnuptial agreement. He also said I needed to do it before Gordon escalated. I asked how much time I had. Paul said it depended on how aggressive Gordon wanted to be, but probably not long. I went home and found Mom in the kitchen. Gordon was upstairs on a conference call. I asked if she had a few minutes. She said of course. I sat down across from her and said I needed to talk about the business. She looked tired. She said Gordon had mentioned that I seemed resistant to new ideas. I said Gordon didn't have authority to implement new ideas. She frowned. She said he was just trying to help. I said help required permission. She said I was being unfair. I said I was being accurate. The conversation went nowhere. She was defensive, unwilling to see Gordon's involvement as anything other than supportive. I didn't push. I'd learned from Dad that you don't win arguments through force. You win them through patience and proof, so I let it drop and went back to work. 2 days later, Gordon sent an email to 3 of our largest tenants, introducing himself as the new co-director of operations and requesting they direct all future communications through him. One of the tenants forwarded the email to me with a polite question about the change in protocol. I replied immediately, clarifying that there had been no change, that I remained the sole point of contact, and that any communications from Gordon should be disregarded. Then I forwarded the entire chain to Paul Everett with a subject line that said escalation confirmed. Paul called within the hour. He said we needed to act now. He drafted a formal notice to Gordon, copied to Mom, stating that Gordon held no ownership interest, no management authority, and no legal standing to represent the business in any capacity. The notice cited the operating agreement, the corporate bylaws, and Kentucky business statutes. It was 3 pages long and polite in the way legal documents are polite when they're preparing for war. Paul filed it with the county clerk as a precautionary measure and sent copies via certified mail. Gordon received his copy on a Thursday. By Friday morning, he'd hired an attorney. I know because the attorney called Paul and said his client disputed the characterization of his role and intended to seek a declaratory judgment establishing his rights as the spouse of the majority owner. Paul said he looked forward to the filing. The attorney said it would be forthcoming. Paul said he'd be ready. That weekend, Gordon stopped speaking to me. He didn't yell, didn't argue, just created a cold silence that filled the house whenever we were in the same room. Mom asked me what I'd done. I said I'd protected the business. She said I'd insulted her husband. I said her husband had overstepped. She said I was being controlling. I said I was following the operating agreement Dad had written. She went quiet. Dad's name still carried weight, even when she didn't want it to. On Tuesday, Gordon's attorney filed a motion in Jefferson County Circuit Court. The motion asked the court to recognize Gordon's equitable interest in the business assets based on his contributions to household expenses, his advisory role in business decisions, and his status as the spouse of the primary owner. It also requested a temporary injunction preventing any sale, transfer, or encumbrance of business assets pending resolution of the underlying claim. The filing was procedurally aggressive and factually thin, but it didn't need to be strong. It just needed to create uncertainty and cost. Paul filed a response within 10 days. The response demolished the motion point by point, cited case law, and attached the operating agreement, the corporate bylaws, and affidavits from our CPA and 2 long-term tenants confirming that I had been the sole operational manager since Dad's death. Paul also moved for sanctions, arguing that the motion was frivolous and filed in bad faith. The hearing was scheduled for mid-April. In the meantime, Gordon changed tactics. He stopped trying to control the business directly and started working on Mom. He framed the legal fight as my attempt to cut her out, to marginalize her, to claim something that belonged to both of us. He said I was acting like a tyrant, that I didn't respect her judgment, that I'd turned her own attorney against her new husband. Mom was caught in the middle, and I could see her starting to believe him. I didn't fight back with words. I fought back with specifics. I showed her the email Gordon had sent to our tenants. I showed her the consulting contract and the legal retainer he'd authorized without disclosure. I showed her the real estate broker request. I walked her through every transaction, every document, every timeline. I didn't editorialize. I just gave her the facts and let her process them. She processed them slowly. She asked questions. She checked dates. She called Paul Everett and asked him to explain the operating agreement in plain language. Paul did, and when he finished, Mom was quiet for a long time. Then she said she didn't realize Gordon had done all of that. I said I know. She said she felt foolish. I said she wasn't foolish, she was trusting. She said trust was supposed to be a good thing. I said it was until it wasn't. The hearing happened on April 18th. Gordon's attorney presented first. He argued that modern marriage created economic partnerships that transcended outdated corporate formalities. He said Mom's ownership interest was effectively marital property and that Gordon, as her spouse, had standing to participate in business decisions. He cited 3 cases, none of which applied cleanly to our facts. Paul responded with precision. He walked the judge through the operating agreement, explained that the business was a separate legal entity with governance structures independent of marital status, and noted that Gordon had never been employed by the company, never contributed capital, and never been granted authority by any valid mechanism. The judge asked Gordon's attorney if there was any documentation of Gordon's alleged advisory role. The attorney said the contributions were informal. The judge asked if there were any board resolutions or written consents granting Gordon authority. The attorney said no. The judge asked if there was any evidence that Mom intended to share operational control with her husband. The attorney said her intent could be inferred from the marital relationship. The judge said inference wasn't evidence. The motion was denied. The judge also granted Paul's request for sanctions, ordering Gordon to pay our legal fees associated with the motion. The amount was $14,000. Gordon's attorney said he'd appeal. The judge said he was welcome to try. We walked out of the courtroom and Gordon was standing in the hallway. He looked at me and said this wasn't over. I said it was. He said I'd regret humiliating him. I said I hadn't humiliated him, I just stopped him. Mom was waiting in the car. She didn't say much on the drive home. That night she told Gordon she wanted to talk. I wasn't there, but she told me later that she asked him directly why he'd filed the motion without discussing it with her first. He said he was protecting her interests. She said her interests didn't need protecting from her own son. He said I was manipulating her. She said the judge didn't think so. He said the judge didn't understand the family dynamics. She said maybe he didn't either. They didn't separate immediately. Mom wasn't ready for that, but something had shifted. She started asking more questions about the business, attending meetings she'd previously skipped, reviewing documents she'd previously trusted me to handle. She was rebuilding her own understanding, reclaiming the space Gordon had tried to occupy. I didn't rush her. I just made sure she had access to everything. In June, Gordon made another move. He contacted the Kentucky Department of Revenue and filed a whistleblower complaint alleging that our business had underreported rental income and evaded sales tax on equipment transactions. The complaint was anonymous, but the details were specific enough that I knew it came from him. The department opened an investigation. They sent an auditor named Rebecca Pitts, a sharp woman in her 40s who arrived with a laptop and 3 expanding files. I gave her everything she asked for: tax returns, income statements, lease agreements, bank records, depreciation schedules. I walked her through every line item, explained every variance, provided supporting documentation for every deduction. The audit took 6 weeks. Rebecca was thorough, professional, and completely unimpressed by the complaint's allegations. When she finished, she issued a preliminary report finding no evidence of underreporting, no improper deductions, and no basis for further action. She also noted in her summary that the complaint appeared to be motivated by personal animus rather than genuine concern for tax compliance. The report was forwarded to the department's fraud division. 2 weeks later, I received a letter stating that the investigation was closed and that the whistleblower's identity had been referred for potential penalties under false reporting statutes. I didn't know if they'd pursue it, but I didn't care. The audit had cost me time, stress, and focus, but it had also created a clean record, a formal verification that we'd done everything correctly. That record became another piece of armor. Gordon's campaign didn't stop. In July, he started telling people that I'd stolen money from the business, that I'd manipulated Mom, that I'd forged documents to cut him out of his rightful share. He said it to neighbors, to Mom's friends, to people at their church. It was slander, clear and actionable, but hard to prove unless someone was willing to testify. Most people just repeated the rumors quietly, uncomfortable but unwilling to get involved. One person didn't stay quiet. Her name was Diane Howell, and she'd been Mom's best friend since college. Diane had watched the marriage, watched the legal fight, and watched Gordon's behavior with increasing alarm. When she heard him tell another church member that I was a thief, she confronted him directly in the parking lot after Sunday service. She told him she knew the truth, that she'd seen the court documents, and that if he repeated the accusation again, she'd retain an attorney on my behalf and file a defamation suit so comprehensive it would cost him everything he'd tried to take. Gordon called her a bitter old woman. Diane smiled and said she had that in writing now, along with 3 witnesses. Gordon walked away. Diane called me that afternoon and told me what happened. She also said she'd started documenting every rumor, every accusation, every person who'd heard Gordon make a false claim. She had dates, locations, and names. She said she was building a case whether I asked for one or not, because she wasn't going to let him destroy my reputation, while Mom was still trying to figure out what kind of man she'd married. I thanked her. I also told her to be careful. Gordon was escalating, and people who escalate don't stop until they hit a wall or run out of resources. Diane said she'd hit harder. I believed her. In August, Mom asked Gordon to move out. She didn't file for divorce, not yet, but she said she needed space to think. Gordon refused. He said it was his house too, that marriage gave him rights, that she couldn't just kick him out because I'd poisoned her against him. Mom called Paul Everett. Paul explained that since the house was owned outright by Mom before the marriage and had never been red-idled, Gordon had no ownership interest. He was a guest, and guests could be asked to leave. If he refused, she could seek a court order. Gordon hired a different attorney, someone more aggressive. The new attorney sent a letter arguing that Gordon had established residency and was entitled to formal eviction proceedings. Paul replied that eviction procedures applied to tenants, not spouses, and that Mom was within her rights to change the locks and remove his belongings. The attorney threatened a lawsuit. Paul said he welcomed it. On August 23rd, while Gordon was at work, Mom had a locksmith come to the house. She packed his clothes, his files, and his furniture into a moving truck and had it delivered to a storage unit she'd rented in his name. She left the keys and the unit address on the kitchen counter with a note that said he had 30 days to make other arrangements. When Gordon came home, he couldn't get in. He called the police. The officer who responded explained that it was a civil matter, that no crime had occurred, and that he should contact his attorney. Gordon stood in the driveway for 20 minutes making calls, his voice rising. Eventually he left. That night he sent Mom a text message saying she'd made a terrible mistake. She didn't reply. She did forward the message to Paul, who added it to the file. September was quiet. Gordon moved into an apartment near Shelbyville. He stopped calling, stopped texting, stopped showing up unannounced. I thought maybe he'd accepted the situation, that he'd move on and we'd settle into the slow procedural grind of divorce negotiations. I was wrong. On September 19th, I received a notice from the Kentucky Board of Accountancy. The notice stated that a complaint had been filed alleging that I'd engaged in fraudulent financial practices in my role managing the family business. The complaint requested a formal investigation and potential revocation of any professional licenses I might hold. The problem was, I wasn't a licensed accountant. I'd never claimed to be. I managed the properties, but all accounting work was handled by our CPA, a firm called Brennan and Associates that had been with us for 12 years. I called the board. The investigator, a man named Stephen Kowalski, confirmed that the complaint had been filed and that they were required to follow up regardless of whether the target held a license. I explained that I wasn't licensed, that I didn't perform accounting services, and that the complaint was retaliatory. Stephen said he understood, but he still needed to complete a preliminary review. He asked for documentation showing the division of responsibilities between me and our CPA. I said I'd provide it. I called Brennan and Associates. The senior partner, Tom Brennan, was already aware. He received a subpoena requesting all records related to our business, including communications with me, financial statements, and tax filings. Tom was annoyed but cooperative. He said the records would show exactly what I'd told Stephen, that I handled operations, leasing, and maintenance, while Brennan handled all tax, audit, and compliance work. He also said he'd be happy to provide a sworn affidavit to that effect. I sent Stephen everything he requested, plus Tom's affidavit, plus copies of our engagement letters with Brennan and Associates. Stephen reviewed it and closed the complaint within 2 weeks. He sent a letter stating that no violation had occurred, that I held no professional licenses, and that the complaint appeared to lack merit. He also noted that filing false complaints was a violation of board regulations and could result in penalties. I didn't know if they'd pursue penalties against Gordon, but the letter joined the growing stack of documents that showed a clear pattern. In October, Gordon filed for divorce. The petition cited irreconcilable differences and requested an equitable division of marital assets. It also included a schedule of assets that listed the house, the business, the warehouse, and our 3 storage facilities. Paul filed a response denying that any business assets were marital property and requesting that the court uphold the prenuptial protections inherent in the corporate structure. The response also included a counterclaim for legal fees, damages for defamation, and sanctions for frivolous litigation. The discovery process started immediately. Gordon's attorney requested production of all business records, financial statements, tax returns, and communications related to business operations. Paul objected to the scope as overbroad and harassing, but the court ordered limited production. I spent 3 weeks compiling documents, redacting proprietary information, and organizing everything into a format that met the court's requirements. It was tedious, invasive, and exactly what Gordon wanted, to drain my time and energy. While I was compiling records, I was also organizing. I created a chronological timeline of every action Gordon had taken since the wedding. The vendor contract changes, the real estate broker contact, the tenant emails, the court motions, the tax complaint, the accountancy board complaint, the defamatory statements. I included dates, supporting documents, and witness statements where available. The timeline was 18 pages long and painted a picture of systematic interference, harassment, and reputational attack. Paul reviewed it and said it was exactly what we needed. He filed a motion for summary judgment on the business asset claim, arguing that Gordon had no colorable claim to any business property and that his litigation strategy was designed solely to harass and extort. The motion included the timeline as an exhibit, along with affidavits from Diane Howell, Tom Brennan, and 2 of our tenants. It requested that the court dismiss Gordon's asset claims, award sanctions, and issue a restraining order preventing further contact with business tenants or vendors. The hearing was scheduled for November 15th. In the week leading up to it, Gordon's attorney tried to negotiate. He called Paul and said Gordon would drop the business asset claims if we agreed to waive the sanctions and the defamation counterclaim. Paul said no. The attorney said we were being unreasonable. Paul said we were being accurate. The attorney said this could get ugly. Paul said it already was ugly, and that wasn't our fault. Hearing lasted 2 hours. Gordon's attorney tried to argue that the timeline was exaggerated, that Gordon's actions were reasonable attempts to understand the business, and that the complaints to various agencies were protected speech. The judge asked if the attorney was seriously arguing that filing false reports with government agencies was protected speech. The attorney backtracked and said the reports were made in good faith. The judge asked what evidence supported that characterization. The attorney said Gordon believed the complaints were valid at the time. The judge said belief without evidence wasn't good faith, it was recklessness. Paul presented next. He walked through the timeline, connected each action to supporting evidence, and demonstrated that Gordon's conduct followed a clear pattern: infiltrate, control, and when blocked, destroy. Paul also introduced evidence that Gordon had contacted 2 of our lenders and suggested that the business was in financial distress, an action that could have triggered default clauses and jeopardized our credit. The lenders had contacted me to verify, and I'd provided clean financials, but the intent was clear. The judge asked Gordon's attorney if he had any response. The attorney said Gordon was exercising his rights as a concerned spouse. The judge said concerned spouses don't file false complaints or interfere with third-party business relationships. He granted our motion for summary judgment, dismissed all of Gordon's claims to business assets, awarded us $42,000 in sanctions and legal fees, and issued a restraining order prohibiting Gordon from contacting any business tenants, vendors, lenders, or regulatory agencies regarding our operations. She also referred the matter to the court's disciplinary counsel for review of the attorney's conduct in filing meritless claims. We walked out of the courtroom. Gordon was in the hallway again, but this time he didn't say anything. He just stared, his face rigid. Mom was waiting outside. She'd attended the hearing, sitting in the back row, listening to everything. When we reached the car, she said she was sorry. I said she didn't need to be. She said she should have seen it sooner. I said some people are very good at hiding what they are. The divorce was finalized in January. Mom received the house, her personal assets, and full ownership of the business, all of which had been hers already. Gordon received nothing except the bill for sanctions. He didn't appeal. His attorney withdrew from representation, citing irreconcilable differences of their own. Gordon moved to Indiana shortly after. I don't know what he's doing now, and I don't care. But the story didn't end with the divorce. It ended with the warehouse. In March, Mom asked me if we should finally sell it. She said the property taxes were still $12,000 a year, the roof still needed work, and maybe Gordon had been right about one thing: it was just sitting there. I said maybe. Then I asked if she wanted to see what was inside first. We drove out on a Saturday morning. I unlocked the pedestrian door and led her through the main floor to the utility room. I opened the secondary door and showed her the file boxes. She stared at them for a long time. Then she asked what they were. I said they were Dad's records. Everything he'd kept, everything he'd documented, everything he thought might matter someday. She asked why he never told her. I said because he knew she'd want to let go and he needed someone to remember. He started opening boxes. We spent 4 hours going through them. Contracts from partnerships that had dissolved cleanly. Receipts from equipment sales that had been disputed and resolved. Correspondence from a lawsuit in the 90s that had been settled with a confidentiality clause. Records of a loan Dad had given to a friend, repaid in full, documented to the dollar. None of it was dangerous. All of it was proof. Proof that he'd been fair, that he'd been careful, that he'd protected what mattered. Mom cried, not because the records were sad, but because they were so perfectly him. Methodical, quiet, prepared. She said she finally understood why I'd fought so hard, why I'd documented everything, why I'd refused to let Gordon rewrite the narrative. I said I learned it from Dad. She said I'd learned it well. Didn't sell the warehouse. We cleaned it, repaired the roof, and leased it to a local contractor for equipment storage. The lease covers the taxes and generates a small profit. The file boxes are still in the utility room, organized and preserved. I check on them twice a year, make sure the climate control is working, make sure nothing's degraded. Someday, someone might need them. Or maybe they'll just stay there, silent proof that some things are worth keeping even when you don't know why yet. Mom and I still run the business together. She's more involved now, more confident. Deanne Howell joined us as a consultant, helping with tenant relations and reputation management. The three of us meet every Monday morning, review the week, plan ahead, handle problems. It's quiet work, steady work, the kind Dad would have recognized. I still think about Gordon sometimes, not with anger but with a kind of clinical curiosity. He was smart enough to identify the vulnerabilities, confident enough to exploit them, but not patient enough to see the traps he was setting for himself. Every false complaint, every defamatory statement, every procedural overreach became evidence. He built his own case against himself, one action at a time, and never realized it until the judge read the timeline aloud in open court. There's a lesson in that, I think. Not about revenge, because I never wanted revenge. I wanted protection. I wanted the truth to be documented, verified, and ready when someone challenged it. Dad taught me that. He taught me that authority doesn't come from being loud or aggressive. It comes from being right and being able to prove it. Last time I saw Gordon was in the courthouse parking lot after the final divorce hearing. He was standing by his car loading boxes into the trunk. He looked smaller somehow, diminished. I didn't approach him. I didn't gloat. I just walked past, got in my car, and drove home. That night I went to the warehouse, unlocked the utility room, and added one more box to the collection. Inside were copies of every document from the divorce, the litigation, the complaints, the sanction. Organized, labeled, dated, just in case. Because you never know when someone will ask the wrong question. And when they do, you want to be ready with the right answer. Mom asked me once if I thought Gordon ever really loved her, or if it was always about the money. I said I didn't know, and that maybe it didn't matter. What mattered was that we'd protected what Dad built, that we'd honored his work, and that we'd done it the right way. Not with shortcuts, not with compromises, but with patience and proof and the quiet certainty that comes from knowing you've documented every step. She said that sounded like something Dad would say. I said it probably was. I've been listening to him my whole life, even after he was gone. His voice was in the lease agreements, in the operating procedures, in the methodical way he'd labeled those file boxes. It was in the lesson that some battles are won before they're fought, as long as you've done the work ahead of time. Business is stable now. Our tenants are long-term, our finances are clean, our reputation is intact. The warehouse sits at the end of that gravel road, unassuming, holding its secrets. And somewhere in Indiana, Gordon is living whatever life he built after this one fell apart. I don't wish him harm. I don't wish him anything. He's just a person who made a series of bad choices and paid the price for them. The system worked the way it was supposed to. Evidence mattered. Authority recognized the truth. Justice wasn't dramatic or satisfying in a visceral way. It was just procedural, final, and correct. That's the part people don't always understand. They think justice should feel like vindication, like triumph. But real justice feels like a door closing, a file being marked complete, a record being archived. It feels like returning to normal after a long detour through someone else's chaos. It feels like going to the warehouse on a quiet Saturday, checking the locks, and knowing that everything you need to prove is exactly where you left it. I still carry the key to that utility room on my keyring. It sits next to my house key, my office key, my car key. Small, unremarkable, easy to overlook. But it opens a door to 42 boxes of proof that my father was a good man who built something worth protecting, and that I was the person who protected it. Not because I wanted to fight, but because some things are worth keeping, even when the keeping is hard. Especially when the keeping is hard.